Hi all, happy Friday. Thought I would answer some of the questions I received this week. If this info is helpful, please comment below and let me know, as y'all know how much I truly love being on video. So one of the questions I'm asked actually frequently is HoneyBook versus Dubsado, which is better from a legal perspective? And honestly, it's not an apples to apples comparison since HoneyBook comes with contracts and Dubsado does not. I've reviewed several HoneyBook contracts and I would say that they are passable as far as minimal mandatory legal requirements, the boilerplate that you see in all contracts, or you should see in all contracts, like limitation of liability and disclaimers. But in my opinion, they could be stronger as far as a much more detailed scope of work, more detailed payment terms, including remedies for you in the event of a default, better boundary setting for you, and for those of you who are in really specialized industries, stronger disclaimers. I also build testimonial releases into my contracts, and I can't remember offhand, but I don't think I saw those in HoneyBook contracts as well. So if you have questions about yours, DM us. Or stay tuned next week. We're going to be launching Power Hours where we can review part of your contract. So stay tuned for that. Or like I said, let us know. If you have HoneyBook or Dubsado, what some of our clients have done is they have bought contract templates or custom contracts from us and just dropped them into HoneyBook or Dubsado. So that's an option. Another question I received this week was about non-competes and non-solicitation provisions and whether you can have them in your client contracts. So non-competes, some of you are probably familiar with these. You'll see them in some employment agreements. And basically they bar an employee from competing with an employer in the same industry in a certain geographic radius after they leave that employer. Non-solicitation provisions basically prevent someone from stealing the clients of the person that they are working with. Without getting too into the weeds in employment law, there's a big difference between independent contractors and employees. Most of you are probably independent contractors and or hiring independent contractors. Employees, you have to pay regular wages to, you have to pay benefits, you have to pay taxes, etc. And independent contractors have a lot more flexibility as far as how they work, when they work, less supervision, and they can work for other clients. So if you think about it, barring a independent contractor from working with other clients in their industry, that's way too restrictive. So non-competes against independent contractors are not really a thing, and they're very, very unlikely to ever be enforced by courts. Non-solicitation provisions, on the other hand, you can add those. They're going to have to be very narrowly drafted in order to be enforced. So I would say definitely have an attorney draft a non-solicitation provision for you. One thing that you can do, regardless of your situation, if you are worried about hiring somebody, is make sure you have a strong confidentiality provision in your contracts and or an NDA. This can help as a buffer if you are either working for somebody and they're giving you confidential information, or you're hiring somebody and they're exposed to some of your trade secrets or other confidential information. Let us know if you have any questions on that. Last thing is GIFs and copyright law. This was brought up in one of my Facebook groups, and the question was whether you can use GIFs on a website you're creating for a client if that's a violation of copyright law. So GIFs it's a really gray area because there's no real case law on point, probably because GIFs are so new. But if you think about it, GIFs are an original work. So the creator of a GIF has copyright rights in that GIF. And it gets even more complicated when it's a GIF that's taken from, say, a movie, or it's a GIF that features a celebrity. I checked out the Giphy, if I'm pronouncing that right, terms of service, and they make it really clear that their GIFs are only for personal non-commercial use. So what's the takeaway for you? Be very careful with using GIFs in your business, especially any that are, say, a movie clip or displaying a celebrity. Because let's say, for example, your GIF is of Kim Kardashian. Well, the original creator of the GIF has copyright rights in that because that's an original work of art. And Kim Kardashian even has a right of publicity in that GIF. So I know a number of you use these in your emails because I'm on your email lists. I would say that's okay. You're probably not going to be bothered with that. But if you're doing something like, say, designing customer websites, definitely something to be aware of. And Disney, to call out Disney for an example, they're extremely litigious. And they do go after people using Disney GIFs. So something to think about and just be aware of.